All right, Dorothy, we're ready for you.
Okay. Good morning, everyone, and welcome to the second session of the 2023 League of Women Voters of Wisconsin Issues Briefing. Once again, we're glad you came and anticipate that you will be too. I'm Dorothy Sky, President of the State League Board. This morning, we will consider citizen action at the state level relative to proposed amendments to the Wisconsin Constitution. Constitutional amendments are a potential means to improve our system of governance while at the same time preserving individual rights. But we must carefully scrutinize proposed changes. Today, we've assembled first-rate knowledgeable speakers to inform us about critical aspects and implications of the currently proposed Wisconsin Constitution amendments. Once again, as on Thursday evening, I invite Joan Schwartz to start us off with an introduction and overview. Joan is a retired attorney. She is currently secretary of the League of Women Voters of Wisconsin Board of Directors. She also chairs the State League's Impartial Justice and Nonpartisan Redistricting Committee and serves on the State League's Legislative Committee, where her portfolio emphasis includes election law, gerrymandering, voting, and money in politics. And just a reminder, folks, please remain muted unless you're asking a question during the Q&A. You're welcome to add questions to the chat during the presentation, and they will be addressed during the Q&A. And these sessions are being recorded and will be available to the general public. So Joan, please.
Thank you. Thank you, Dorothy. We will have presentations from Attorney T.R. Edwards from Law Forward about the constitutional separation of powers doctrine in Wisconsin, Margarita Edelman, Vice President from the League of Women Voters of Vermont on the constitutional amendment on non-citizen voting, Attorney Michael Haas, attorney for the City of Madison, about a constitutional amendment regarding private money for our elections, and Jen Miller, Executive Director for the League of Women Voters of Ohio, and she'll share how that league and its partners were successful at raising awareness to help achieve a no vote in Ohio for passing constitutional amendments. Next slide, please. Wisconsin's Constitution has lived a long time and relatively healthy life compared to most American state constitutions. Wisconsin has retained its 1848 Constitution, which is the oldest state constitution outside of New England. We have amended our Constitution 145 times in 158 years, a frequency that may at first blush sound high, but in fact, Wisconsin's amendment rate is lower than that of 28 states. Next slide. A key question about the use of state constitutional amendments has been debated for many, many years. Should state constitutions be concise, relatively unchanging documents that embody the most fundamental principles of government, or should they be faithful mirrors of social change? In other words, the controversial social policies do they belong in the Constitution, or should they be left to the legislature to adjust through bills and statutes controversial areas to the ebb and flow of public opinion? Essentially, what must be considered is whether amendments incorporating controversial social policies is good for the state. Next slide. A key question specifically for Wisconsinites at this time is how and why our gerrymandered legislature is using the amendment process so frequently. This issue raises so many questions. How are we to evaluate the constitutional process to enact social change? How do we assess the issue of the increased number of constitutional amendments, proposed by Wisconsin's gerrymandered legislature, some of which were vetoed by Governor Evers when they were passed as bills? Are these amendments being proposed to advance controversial contemporary social agendas? Next slide. A little bit about how our Constitution is amended. As in other states, Wisconsin's requirement is that two consecutive legislatures in 2 consecutive years must approve the same proposed amendment. They're called first and second consideration. First consideration is those that will not appear next year. And its amendment is proposed in one legislative session by both houses and is approved by the majority of the members elected to each of the houses. Second consideration amendments are those that will be coming up on the ballot next year. An amendment is proposed in a consecutive legislative session the following year and approved by the majority of the members elected to each of the houses. And then the legislature submits the proposed amendment for placement on the ballot to the public. If the people approve and ratify the amendment by a majority of the electors voting, the amendment is enshrined in the Constitution. Some legislatively referred constitutional amendments, which voters have already approved, have been challenged in the courts. The 2006 amendment, this is slide 6, I'm sorry, Brandy, next slide. A 2006 amendment approved by 59% of the voters declared, quote, only a marriage between one man and one woman should be valid or recognized as a marriage in this state. Then in 2016, the U.S. Supreme Court legalized same-sex marriage, nullifying the Wisconsin constitutional amendment. Surprisingly, though, this amendment still remains in the state constitution. We're ahead of ourselves. Can you go back? And back one more. Thank you. The 2015 amendment allowed justices to elect the Chief Justice rather than continue with the tradition that the longest-serving justice acts as a chief. As a result, conservative members of the Wisconsin Supreme Court fired longtime Chief Shirley Abramson, a liberal, and installed a conservative in her place. A 2020 amendment expanded the rights of crime victims, known as Marsy's Law, which provided crime victims with 16 rights, including rights to privacy, timely notice of release, full restitution for the accused, etc. This amendment passed with 75% approval. Attorneys for defendants opposed this amendment because of concern that the defendant's right to file pretrial motions and to challenge certain actions of the government could and does come in conflict with the victim's right to dispose of the case quickly. Initially, this amendment was held to be unconstitutional by a Dane County Circuit Judge because the ballot questions did not comply with constitutional requirements. They were misleading, included incorrect information, and incorporated more than one subject matter, which is not constitutionally permissible. Ultimately, however, despite these constitutional problems, the then Wisconsin Supreme Court affirmed the amendment. Next slide. Most recently, 2 amendments were passed this year. The amendment on conditions of release before conviction passed with 66.55% approval rating, and the amendment on conditions on cash bail passed with 67.57% approval. These amendments are being challenged in the circuit court, this time by Expo, a Wisconsin organization that advocates on behalf of formerly incarcerated people, and Wisdom, a statewide faith-based organization. Both are alleging that the amendments were not submitted in a timely manner to the proper election officials. Ultimately, this case will wind itself to the Wisconsin Supreme Court, more than likely. While the challenge to these 2 recent amendments is on procedural matters, there were many concerns about substantive provisions of the amendment, including the League of Women Voters of Wisconsin that opposed these amendments on grounds of their being misleading and incomplete on factual issues. The First Amendment, conditions for release before conviction. Prior to the passing of this amendment, a judge assessed several criteria prior to deciding pretrial release of an accused person. First, to assure the accused person's appearance in court. Second, to protect members of the community from serious bodily harm. And third, to prevent the intimidation of witnesses. Most significant in the constitutional amendment was the change in language to the second criteria to protect members of the community from, quote, serious bodily harm. The legislature proposed and the amendment that passed deleted the word bodily and included only the words serious harm. This amendment did not include a definition of serious harm when it came before the voters. They deleted the word bodily because it believed that the statutorily defined term of serious bodily harm was too limited, and the definition for that was death or serious permanent disfigurement. And so they thought that that was too limiting and they changed it to just serious harm. But as I said, not defined in the amendment put to the voters. They then passed a trailer bill, which defined serious harm very, very broadly to include emotional harm, mental anguish, property damage, economic loss, among many other ideas. Some potential serious social societal consequences of this amendment are it added additional costs on local taxpayers, and it increased the disparity in the treatment of people of color who have not yet been convicted of a serious crime, not yet defined, but are not released prior to trial. Next slide, please. The league also opposed the condition of cash bail amendment. The current language before the amendment was passed provided only one condition for a judicial decision of imposing cash bail. It imposed it only if the judge wanted to assure the appearance of the accused in court. The legislature added what is called, in legal language, the totality of circumstances test, which specified 5 more conditions for a judge to consider when deciding to impose cash bail. The added criteria were the seriousness of the crime, previous convictions, the need to protect the community from serious harm, also again not defined, and prevention of intimidation of witnesses. Just to note again, the legislature passed a trailer bill after the amendment passed, and they passed another 100 changes to the total of circumstances test. What was also not included in this amendment was awareness of the serious legal issues that judges in their discretion factor into their decision about whether to impose cash bail. They consider the principle that accused persons are innocent until proven guilty, and that rights should not be burdened. And the due process clause of the Fifth Amendment and the executive bail prohibition under the Eighth Amendment also need to be considered. Other societal concerns that the league were concerned about: a 2-tiered system of justice, one for the wealthy and one for everyone else, exacerbating the financial inequities in the state's bail system by adversely impacting people with low income. Also, another concern, exacerbating racial disparities in the justice system, and also the fiscal impact of judicial decisions on the increasing costs for local jails. What appeared to voters were amendments that would make our community safer. But in actuality, when these proposed amendments are viewed from the state's constitutional separation of powers doctrine, the legislature intruded upon a core power of the judge to exercise his or her discretionary judgment. So these amendments were placed before the voters without all the information about the impact and consequences of our vote. Next slide. The key idea behind this requirement of the approval of 2 consecutive legislative sessions is that the amendment would be reflective of the people's votes. But with a gerrymandered legislature, the odds of a second legislature being composed differently from the first legislative body are slim to none. In fact, because of gerrymandering, the representatives and senators in the legislature do not change much from year to year. Since 2012, even when Democrats have won as much as 53% of the statewide vote, they've held no more than 39 of the 99 assembly seats. In the same period, even when Republicans have won as little as 44.8% of the statewide vote, they've held no fewer than 60 of the 99 assembly seats. So, while 148 amendments have been added to our Constitution in 157 years, averaging about 1 per year, this legislature has had 2 constitutional amendments passed this year and has proposed another 3 for next year, and yet another 3 for the following year. What are the currently proposed amendments that have been proposed? Well, we'll talk about the ones that are the second consideration first, which will come up for the next election. The first is a proposed amendment to bar municipalities from allowing non-U.S. citizens to vote in local elections. The Wisconsin Constitution currently guarantees that, quote, every citizen under age 18 and over, over 18 and over is the qualified elector. The proposed amendment changes the word every to only which means that non-citizens cannot vote for elected officials in municipal elections or for local referendum. Marguerite Edelman will discuss the ramifications of this proposed amendment in more depth. A second consideration amendment forbids the use of private grant money to help administer elections. Governor Evers vetoed a bill in 2021 that outlawed private election grants. It's now in a constitutional amendment. Attorney Michael Haas will discuss this proposed amendment in more depth. A second consideration proposed amendment restricts the governor's ability to allocate federal funds without the legislature's approval by joint resolution or as provided by legislative rule. The legislature does determine how state tax dollars are spent, but determination of how federal dollars are spent lies with the governor and has been law since the 1930s. This amendment would prohibit any executive branch official or department from allocating any federal dollars, including emergency federal funds, without first securing approval from a legislative committee, more than likely the Budget Committee. The legislature claims it should not delegate what it calls its sole power to determine how money should be appropriated, and thus this measure allows it to retain the power of the purse. The legislature alleges that this amendment is needed because the Republic has been, quote, put in jeopardy by being absolutely reckless, that there have been billions of dollars in fraud, and that inflation has been jaw-dropping because of the governor's appropriation of federal funds. It thus argues that the measure simply lets voters choose who should have final say over how federal funds are spent. Governor Evers vetoed such a bill last year that would have required the legislature to sign off on his plans for spending $4.3 billion in federal COVID relief money coming to our state. Clearly, if future pandemic or emergencies were to occur and federal relief money came to the state, the legislature would have to approve how it was to be sent, a procedure that could possibly be denied or delayed when needed in a timely manner in the form of direct aid to households, businesses, to enable the economy to recover quickly. In addition, the legislature has attempted to tell Governor Evers how to spend Wisconsin's $2.5 billion share from the American Rescue Plan. They have attempted it many times, and all have been vetoed by the governor. This constitutional amendment again triggers the constitutional separation of powers doctrine in that the legislator intends to intrude upon the core power of the executive branch. Governor Evers actually just filed a lawsuit alleging the legislature's infringement on the executive branch by vetoing executive branch decisions by means of a legislative committee, just the committee, which do not have a constitutional basis to veto executive administrative decisions. Next slide. First consideration, those that will come up in 2 years. First one is a proposed amendment requiring photographic identification for all elections. We already have a current photo ID law, which was enacted in 2011, and now they want to make certain that this gets to become a constitutional amendment. They believe, and they commented in hearings, it's necessary to incorporate this issue into a constitutional amendment in order to avoid a possible challenge to the law from the current Wisconsin Supreme Court. A second constitutional amendment proposes to increase the bar to raise taxes in Wisconsin by requiring a supermajority, 2/3 of the Senate and Assembly vote in favor of a proposed tax hike. The legislature claims that making it harder to raise taxes is a way to make Wisconsin a more attractive place to live. However, the amendment would restrict changes to state law that may be needed to respond to changing issues, new challenges in the economy not knowable today, for basics like supporting schools, sustaining healthcare, fixing roads, etc. A third amendment provides freedom to gather in places of worship during a state of emergency. This amendment provides that the state or political division of the state may not order the closure of or forbid gatherings in places of worship in response to a state of emergency at the national, state, or local level, including any emergencies related to public health. Clearly, this amendment is in response to all the issues that arose because of COVID, and the legislature wants to make sure that, quote, no religious rights are burdened by any governmental mandate to protect the community at large. This amendment has not yet been voted on by either chamber, but those votes will obviously come. Next slide. The reality of adding constitutional amendments is not as salutatory as the legislature claims. It claims that these changes in the Constitution are to protect Wisconsin's fundamental rights, that they are pro-democratic, and they allow the public the opportunity to directly voice their final agreement with an issue. But what are the real reasons for this increased number of proposed constitutional amendments? As already noted, one main reason is that when the legislature passes bills, the governor, who was elected statewide and not affected by the gerrymandered legislative maps, can and does veto them. Secondly, with the gerrymandered legislature we have had for the last 10 years and still have today, the legislature can lock into the Constitution social policies that will bind future legislatures. It wants to preserve their priorities after the Wisconsin Supreme Court changed to a new majority in August. And also, it wants to substitute its judgment over the executive and judicial branches. Next slide. For all the legislative statements about the constitutional amendments being pro-democracy and good for the state, it's legitimate to ask why the legislature will not trust us to have ballot initiatives, which Wisconsinites have demanded in order to have a final say on certain issues, as happens in states like Michigan, Ohio. Not only has this legislature refused ballot initiatives, but it just made illegal the use of advisory referendum, which has been what Wisconsinites have used for years to make clear our positions on how to get fair, transparent representative and congressional maps, an independent redistricting commission, getting money out of politics, among many other issues of concern for the public. Ballot initiatives are the way to trust the people of Wisconsin and do directly what voters want for our state. So now is the time to be mindful that we honor and preserve our Constitution. And now is the time to be mindful that our Constitution not become the repository for a flurry of controversial, restrictive social policies with misleading and ambiguous language about the gerrymandered legislature is proposing, which, if passed, will be enshrined in our Constitution. So, with us to discuss the separation of powers issue doctrine is attorney T.R. Edwards from Law Forward. T.R. has spent over a decade working in labor, community, and political organizing, and currently serves as the community outreach chair for the Wisconsin Association of African American Lawyers. T.R.?
Thank you kindly, Joan. Am I able to share my screen?
Yes, she'll bring them up.
Oh, I was told that I'd be managing my
Oh,
own.
I'm sorry. You're bringing yours up. Yes, thank you.
Okay, got it.
Molly, did we make TR a co-host yet?
Yes.
Okay, you should be good. TR, are you
Awesome.
not able to see the screen
I
share?
am. I can see it now.
Okay.
I am pulling it up. Hopefully, you guys can start to see my slides now.
Looks
All
good.
right. So a few things that I want to cover and share before we get started. First and foremost, again, my name is T.R. Edwards. I'm an attorney at Law Forward. This is our current staff and two of our co-founders, Jeff Mandel and Doug Poland. They're attorneys at Stafford Rosenbaum who've been working on election law in the state, in Doug's case, for the better part of the last 40 years. They have been both incredible mentors to me personally and have really been instrumental in helping us kind of reshape and reformulate and frankly push back against some of the terrible decisions, laws, and frankly the maps that we are currently battling today. So I'm thankful for them and I'm thankful for our team. When we initially started, when I first came on board earlier this year, we were having a process as we're starting to really develop what we believed democracy to be. This is a list of some of the words that came up: access to power, fair representation, accountable, respectful of coordinate branches of government. Like there are so many different aspects that build into a form that build into a form that is supposed to be a representative democracy or republic democracy is the one that is enshrined both in our state constitution and our U.S. Constitution. So these are just some of the ideas that help us kind of conceptualize what government looks like. So Law Forward has really kind of taken on the goal of trying to establish basically what those boundaries look like and what that work can be through strategic litigation that makes long-term systemic changes that frankly Wisconsin needs at this point. Rather than fight individual cases as they arrive, taking on individual clients for a particular change, democracy, frankly, is our client. So the work that we do, whether it's fair maps or other cases, it's really trying to respect and create a democracy that works for everyone. Some of the democracy work that we've been doing as of late, the election denial and challenges under Weck versus LeMahieu, partisan gerrymandering, or excuse me, redistricting litigation in Clark versus Weck, and then also voting challenges in Warner versus Dankmeyer, which is a 26th Amendment case, Brown versus Weck, the League of Women Voters versus Weck, as well as potentially participating in the Evers versus Markline case, which I'll discuss more fully later. So when I talk about separation of powers, the first thing I think that is important to understand is that our government is currently set up to not only have three separate co-equal branches of government, similar to the U.S. Constitution, as enshrined in a Supreme Court case in our state by State ex Rel Friedrich, but also in our Constitution. Articles 4, 5, and 7 outline the different roles for both our legislature, our our judicial branch, as well as our executive branch. Those different areas, they do have their set of core powers, core exclusive powers, which can only be exercised by them. Some of those were helped to be clarified in frankly not so positive ways in 2019. But there are also shared powers that each branch of the government, including the administrative agencies that are within our government, share as well. However, in a suit filed this month, the governor is attempting to frankly re-enshrine and frankly identify and clarify those key relationships and boundaries between the different elements of government. In this lawsuit, Evers versus Markline, Governor Evers has taken a very direct and frankly courageous step to really go against what is happening at the legislative level, because frankly, even before the lame duck laws that the League of Women Voters case attempted to defeat, there had been a constant encroaching on the both power of the administrative branch as well as the power of the executive branch by the legislature. In this lawsuit, Governor Evers is attacking the legislature's ability to basically veto legislation that has already been passed through committee action. So basically using functions of the legislature to defeat functions of the legislature and the government where they're supposed to work together in a shared power to actually create legislation. When it comes to creating legislation, while it is indeed the responsibility of the legislative branch to draft it, they still have to present it and have it go through the formal process, whether that is the governor signing it within 7 days or whether that is a override, which is also a power of the legislature, if indeed the governor vetoes it or they want to veto, or he partially vetoes the legislation. Either way, that's part of the process that they're supposed to follow before making those changes. In the cases of these three specific legislative vetoes, this is where laws were created. For instance, with the Joint Committee on Employee Relations and withholding UW employee raises for over 35,000 employees across the state. In this particular instance, there is a separate process after the budget allocation is made for the legislature to then come back and actually approve the actual final giving of those raises to the employees. This is frankly, in my opinion, an asinine situation where you're creating an extra step and an extra layer that frankly in the last 40 years hasn't been used in this way, but it's being used this way now in an attack against DEI efforts. But it hasn't been used in this way before, but it created a situation when this law was passed in 1974. It created a situation where it gave the legislature an extra step after a budget is passed to actually implement what was passed in the budget. As in this particular instance, as opposed to removing the 32 million, after removing the 32 million from UW system, in response to or what they believed or calculated to be the cost of all DEI programming within the state, uh, the legislature decided to require that those positions, all DEI positions, all the positions that go into making people that look like me feel comfortable on campus, um, and people of various different backgrounds, women, people, homosexual, like whatever your particular thing is that you needed to feel more comfortable on campus, they decided that it was no longer valuable to the institution and frankly was harming the institution. But the governor, thankfully, issued a veto removing that requirement and allowed those people to keep their positions and allowed the UW system to find opportunities for those people to continue working. However, he was not able to reinstitute that 32 million. But now in this process, they've decided to retroactively require, basically by holding the raises for all 35,000 UW employees hostage, to require either the elimination of those positions or some other reallocation of the funding, to basically get rid of the programming at the state level. This is an override, in my opinion, of the governor's veto and an override of the legislative process. It's giving the Joker Committee, which is a group of 8 people, 6 of them Republicans, and there are 8 leaders. It's the Senate Majority Leader, the House Leader, or excuse me, the Speaker of the House, and um several other, the Senate pro tempore, all these weird random titles that are given and frankly are the way they are because of the gerrymander. But these leadership positions are now having the ability to not only override the governor's veto, but override the entire legislature's voice by making these types of steps. Similarly, but not as bad, in terms of such a small consolidation of power. You had the Joint Finance Committee, which is limiting the DNR's ability to go out and purchase and redevelop new land, in excuse me, with the hopes of limiting their ability to support, whether it be people of color or people on Native American lands. It's basically just the Joint Finance Committee taking an extra step after having already by law granted the ability for DNR to do these things. That part kind of dives into non-delegation, which is something else that I want to discuss. So non-delegation is an issue that also comes up within the separation of powers context, because what that is, non-delegation is basically the restriction on the ability of the legislature or the governor to give away powers of the legislature to administrative bodies unduly. That being said, the administrative agencies exist for the express purpose of carrying out the executive functions and helping the development and the promulgation of the rules necessary to actually go out and do the work that the legislature has commanded. So for better or worse, these administrative agencies exist. They need to be empowered to go out and do their work so that the good or bad work of our state legislature can be done to actually support the will of the people within our state. When the Joint Finance Committee then is able to go back after their work and prevent their work from happening through a legislative veto, it prevents the ability of both the governor to have his role and the administrative agency to actually carry out the proper functioning. It's basically retroactively creating a situation where no law that is passed under this Knowles-Nelson land grant, because of the requirements for the purse, and basically the legislature having to approve the release of the dollars, it doesn't allow them to effectively go out and do their work that they were commissioned to do by the entire legislature and the governor. Similarly, with the Joint Committee for Review of Administrative Rules, there's 2 issues here affecting DSPS, specifically the agency required for public certification of people that are either social workers, providing nursing and counseling. And then also similarly, there were challenges to the building codes. Can't speak too much to the building codes, but one thing I can speak to from personal pride is the work that I have done against conversion therapy. And I can tell you that it does kill people. And the challenge with this type of legislative veto is that it allows such a small group of people, I believe on that committee is 10, such a small group of people, not representative of the state, to basically make a decision that doesn't allow people who are doing the work every day to have the type of power that they need, frankly, to go out and actually make a difference in kids' lives and change the rules so that we're providing services accountably, and that we are preventing the types of policies, the types of therapies that are harming children. So that's a little bit of breakdown of Evers versus Markline. Again, it's an incredibly courageous move on the part of the governor. Our organization is planning to support. We're still actually developing in what way, whether that will be representing an individual client or another agency that may not be reflective of these particular issues within the separation of power context. But if indeed that we're going to make a government that makes sense, we have to continue to work around the periphery on issues like this so that the legislature is not continuously encroaching on the powers of other branches. We recognize that we have an opportunity with the court that's able to properly listen and hear cases, and that on the merits, the governor has an incredibly powerful case in this instance, and it's a great example of how you can reset and reestablish the separation of powers. Before I go, I also want to mention a little bit about Clark versus Weck. Within our case, this is the redistricting litigation case that you may or may not have heard of. For those of you that participated in the briefing on that earlier in the week, I won't spend too much time breaking it down, but what I will say is that we do make a separation of powers claim within this case as well. In that case, our separation of powers issue becomes very simple. What we believe that the judiciary did in this case, the Supreme Court in the Johnson case, basically violated the separation of powers doctrine that's enshrined within our Constitution by, instead of forcing the legislature's maps to go back through and actually succeed through the political process, meaning whether it was the governor signing whatever they produced, or them having, a legislative veto, or a legislative override of the governor's veto, they instead implemented that map with no changes that the defendants, the state legislature, had put forth in that litigation. So, in our opinion, that was the judiciary branch in that case overstepping their boundaries by not either returning that issue to a special master or developing new maps on their own. So within that case, that also becomes a separation of powers. But as was mentioned earlier, the gerrymander itself becomes an issue of separation of power. As I mentioned, many of those committees that have the power of legislative override are dominated by people who frankly shouldn't constitutionally have a right to sit in those positions. They shouldn't be in leadership positions if they don't actually reflect the majority of our state. So all of these cases frankly work together to basically reinstill and reinforce the boundaries that are supposed to be in place in our government, and frankly clarifies where we should be going forward. So I'll stop there. If there are any questions, I'm definitely open to hearing them. I know it's very dense material speaking about the Constitution, but it frankly for me is very fun. See
Joan,
some in the, oops, go ahead.
this is Deborah. Tiara, we're going to hold our questions till the end, if that's okay with you. And I want to
Perfect.
let Joan know that Marguerite's having some issues connecting. If we could move next to Michael Haas.
So thank you, TR. Up next, we welcome Michael Haas, City Attorney for the City of Madison, to speak on private money for elections. Michael became City Attorney in 2020 and previously worked for the State Elections Agency for 12 years. I'm sorry, I'm not on video. And previously worked for the State Elections Agency for 12 years, including as interim administrator for the Wisconsin Elections Commission. Welcome, Michael.
Thank you. Good morning, everybody. Happy to be here. Let me see if I can handle sharing my screen. Hopefully you can see that, and please let me know if you cannot. No, I cannot see it.
We're seeing your email right now.
All right. Okay, let me try that again.
I can also share it for you, Michael, from my screen if you would like, and you can just prompt me for the next slide.
Yeah, let me just try one more time. Is that working?
Yes.
Great, okay. Happy to be here. Thanks for the invitation. My name is Michael Haas. And as Joe mentioned, I'm currently the Madison City Attorney and was previously with the State Elections Agency. So I've been living with these election issues for quite a while. And I've been asked to discuss the constitutional amendment that would prohibit the use of private grants in elections. So this is currently Senate Joint Resolution 78. I won't read the entire excerpt, but essentially, I think the key phrase here is that the state and no political subdivision may apply for, accept, expend, or use any monies or equipment in connection with the conduct of any election. So this was actually very timely because this week there was some action to put this on the ballot in April. This resolution passed both houses in the last legislative session, and this past Tuesday, it passed the state Senate, and then it passed the state assembly on Thursday, meaning it will be on the referendum, or the referendum will be on the ballot on April 2nd of next year. So as you probably are aware, this arose after the Center for Tech and Civic Life made private election grants to municipalities all over the country in 2020, mainly in response to the pandemic. And nationwide, this organization, nonprofit organization based in Chicago, issued about $350 million of funding to counties and municipalities across the country. They used a formula based on the eligible voting population. I think it came out to about 81 cents per voter. Grants were issued to every local jurisdiction which applied, which is over 2,500 jurisdictions across the country. There was a lot of publicity, of course, in Wisconsin when the initial grants were issued to the 5 largest cities, but eventually there were grants issued to many municipalities in Wisconsin, and every municipality that applied for the grants were awarded grants. To put the $350 million into context, that was about the amount that Congress appropriated to support election administration in 2020. Typically, there are $2 to $3 billion spent on election administration in an election cycle. The center issued about $10 million to 218 Wisconsin municipalities. The city of Madison received close to $1.3 million in 2020. The grants were intended to assist in the administration of elections, as I said, in the midst of the COVID-19 pandemic. I'll maybe pause right here and address one of the questions that is on your agenda how are elections, local elections typically financed and where do the funds come from? Well, of course, it comes from a mix of state and local funding. As you probably know, municipalities are restricted in the funds that they can raise. Primarily, it's through the property tax to support its general fund. And of course, there's shared revenue funding that comes from the state as well. So that's typically how local elections are funded. Until this debate and this constitutional amendment proposal, there was any question about whether or not municipalities could accept private money to help administer elections in their jurisdiction, just as municipalities accept donations and private funding for many of their functions. As you recall, 2020, the beginning of 2020, we saw the COVID-19 pandemic. At the time, I was working at the Wisconsin Elections Commission, and local election officials were really under fire as far as trying to figure out how to manage the spring election in April. To give you an example here of the impact that the pandemic was having in the spring, Madison only opened 62 of its typical 92 polling locations. Municipalities all across the state lost thousands of poll workers and polling locations of organizations or maybe school buildings that served as polling locations that were closed. And as you recall, there's a lot of concern and fear about having contact with other individuals at the time. And both the state and local officials were trying to figure out how to conduct an election in a pandemic. Wisconsin, as you may recall, was the only state to conduct its presidential primary in April in the middle of the pandemic. Most other states postponed or canceled their primaries. So personal protective equipment, plexiglass, hand sanitizer, all kinds of supplies that local clerks had never considered that they would have to be responsible for purchasing. Those were all in short supply, and people were scrambling under a tight deadline to figure out how to conduct the elections. The city of Madison went through its entire election budget for 2020, conducting the February and April elections. And of course, there was no additional state funding forthcoming from the legislature. In fact, the legislature essentially just adjourned for the rest of the year once COVID hit. I have probably told this story maybe to some of you in the past, but I remember sitting in the Elections Commission office the night before the April election. There was a special meeting of the Elections Commission. There were two lawsuits going on. One was in front of the U.S. Supreme Court, and one was in front of the Wisconsin Supreme Court to even decide if we were going to have an election the very next day. Obviously, clerks have to be up early in the next morning. Some of them may have gone to bed not knowing if we were going to have an election the following day. And I just remember sitting in that meeting thinking, this is not the way to run a democracy. So when we look at the funds, how the funds were used, there's been a lot of discussion, and we will get to the debate about whether the funds affected turnout or increased turnout for one party or the other. This is how municipalities actually use the funds. In the city of Madison, they purchased drop boxes, they supported in-person absentee voting, as I said, purchased supplies, additional pay for poll workers because of the difficulty in getting and keeping poll workers. They use the funds for renting and cleaning polling places, temporary staff support for the clerk's office, costs again for real estate or satellite election offices, They used it to purchase supplies for absentee voting, voting equipment, and then nonpartisan voter education. So if you look at the debate about whether or not these funds actually affected turnout or gave one party an advantage, there's very little in this list that I think you could point to say that that actually had any impact in communicating with voters or encouraging turnout. Just to kind of boil down the basic debate that we're having here regarding private election grants, supporters of the grants argue that they were necessary to ensure that all eligible electors were able to vote, especially during the pandemic. Those who oppose the grants argue that they overwhelmingly favor Democratic-leaning jurisdictions and had the potential to tilt elections by increasing voter participation of Democrats. So coincidentally, and I guess fortunately for me, about a week after I was invited to give this presentation, there was an academic paper issued by researchers at Stanford and UCLA on this exact issue about whether or not private grants advantaged the Democratic Party in 2020. So I thought I would share some of those findings. You can find the abstract of this paper at the link in the presentation. So these researchers, these are kind of bottom line findings. It was a statistical analysis. There are nuances to the analysis, but I tried to just pull out their basic findings. And they of course use, being statistics and data researchers, a lot of complicated terms regarding regression analysis and other kinds of equations that I would not understand. So I just pulled out the conclusions, and these were the bottom line findings that, first of all, Democratic-leaning counties were more likely to apply for grants in 2020. They identified a number of reasons that was probably the case. Counties across the state being the ones that typically run elections, and the Democratic-leaning counties probably being more urban counties, more largely populated, possibly more in need of funding to conduct their elections, and probably less likely to have opposition to accepting the grants. The key finding, I think, was that these private grants did not noticeably advantage Joe Biden in the 2020 presidential election. Also that, Wisconsin, our municipal clerks are not partisan officials. In other states where counties run elections, those county officials are partisan. And their nationwide findings were that the turnout did not depend on whether or not the jurisdiction was run by a Democrat or a Republican election official. And also they found that private grants do not pose a substantial new risk of influencing election results. And as somebody who's been in election administration, these findings do not surprise me, in that the grants are used to administer the elections, not to influence the election results. A few more findings here. They tried to focus not only on nationwide, but they picked out really the 5 battleground states in 2020. Found that the effect of the grants on voter turnout was consistent with the full nationwide analysis. They also found that the effects on turnout and on the share of the Democratic vote are not larger in a jurisdiction because it is more or less populous, more or less urban. They also looked at the difference between small grants and large grants in those jurisdictions, and found that actually in smaller grants, typically smaller jurisdictions, that correlated with a slight increased Democratic vote share as opposed to more urban areas that received larger grants. Then focusing on Wisconsin, which was a special case in the study because it is run at the municipal level, these researchers handled Wisconsin different. And the findings were mostly consistent, but slightly different because the researchers have not acknowledged that, the countywide impact could not fully be assessed when municipalities were the ones receiving the grants. But the bottom line here was that in Wisconsin, municipalities that used the grants had a modest but actually statistically significant drop in turnout of a little less than 1%, which obviously is not consistent with the assertion that grants improved the turnout in Democratic areas. So I'm just suggesting a few questions to think about as you ponder this constitutional amendment. I actually testified in front of the legislature when the legislation was being considered that would have prohibited election grants. And I suggested that, at least as the way that legislation was drafted, it would have prohibited pretty innocuous and common practices where you have maybe local businesses or organizations donating food to poll workers on election day. And actually organizations that might provide a polling place at a reduced rate, and whether or not that would be considered a donation. The other question I posed, looking at how the city of Madison operates, is why is election administration the only government function that is being targeted to prohibit benefiting from public-private partnerships? I asked our finance department to run a spreadsheet over the last 5-6 years of private funding that the city has received to assist with everything from the police department to parks, public health. The city, over those years, the city has received funding ranging from, I think, $1.5 million to $5 million in private funding to assist various functions of the local government. And again, this I think emphasizes that it's the administration of these functions that is being benefited. A couple of other questions, and this is something from that the research paper highlighted, is just the public, the backlash and the questions about the integrity of the election being affected by the private grant. Whether or not you subscribe to that belief, does the fact that it is out there mean that policymakers should consider that maybe it's best not to use private grants just to improve the confidence in the election results? And finally, I think a question that's on all of our minds is whether the state is going to step up and increase funding if it is going to prohibit private election grants and say that's just essentially a public cost, and we're going to provide more public funding in order to alleviate that question about public confidence. So I will leave it there. I'm happy to address any questions later on. And again, thank you for the opportunity to present on this issue.
Thanks for joining us for Issues Briefing Session 2, Part 1. For the rest of the presentation, please click on the recording for Session 2, Part 2.